Defendant, Vetcare Ltd.
Yes.
I didn't get the memo about court dress, which is why I'm wearing the.
That's right. And in fact, the temperature in this court is quite.
It
quite
is.
cool.
We'll probably get some refugees coming in there to enjoy the.
But anyway,
Not
fine in either dress.
My lord and my ladies have seen the roster of council, which has a rather international cast. I lead appearance. I lead Mr. Strelitz for the appellants, Mr. Totsi and Mr. Hanker for the respondent, IVL. I assume that the court has had a chance to look at our skeleton arguments.
Yes.
And I'm going to just inquire on the basis that you're going to finish 4:30. I will hope to be done sometime between 12:30 and 12:45 in opening to give Mr. Totsi a chance to get his feet into the table, so to
Yes.
speak, before the short adjournment. But in a most gentlemanly way, he informed me he doesn't like holding people to time estimates, factors that those of us who've been doing this job for a while do appreciate.
Yes.
My lord, I'm going to assume that I don't need to go through the basic facts and the, if I may respectfully say so, and maybe the concise judgment is on the judge heard. I'm going to dive straight into the law and ask you to look at the authorities bundle. I'm going to go through the cases, acknowledging, of course, that the overall framework has been set by the summary in the L.A. Michael case, which we'll come to. But that doesn't displace the need to consider why it is that particular factors might be relevant in the balance which is involved in this exercise, and which we say with respect the judge will have failed to carry out. So can we start with the case called Gandhi, which is the Victorian case that initiates it? We're not going to spend very long on it. That's at tab 1 of the authorities bundle.
Yes.
Most of the report is concerned with preliminary issues that have nothing to do with this issue, but at pages 27 to 28 of the bundle, you can find the key passage in the judgment of Lord Justice Bowen. And what he refers to there is to the husband in divorce proceedings having taken part in earlier decision where, as it's put, and one can see that about 8 lines up, in order to arrive at the second ground of a decision that has been reached the year before, it was taken for granted, with the acquiescence of Mr. Gandhi by his counsel, that Mr. Gandhi still acknowledged a continued liability to bear the expense of maintenance education.
Sorry, Mr. Bear, you're talking.
I'm sorry, I said 27 and I
You're
misread
talking
it.
to your screen rather than to us.
I'm so sorry.
So you need to
my lord.
keep your voice up if you.
Yes, I will, of course. I do apologise. Towards the bottom of page 26, about 5 lines into the judgment of Lord Justice Bowen, where he's summarising the earlier decision, so the first decision from which there had been a departure in the instant proceedings, and he says, in order to arrive at the second ground, which is vital to the decision, it was taken for granted, with the acquiescence of Mr. Gandhi by his counsel, that Mr. Gandhi still acknowledged a continuing liability to bear the expense of the 2 youngest children. And then over the page, first break on the page, says the husband, having got the benefit of our decision on the appeal from the divorce court on the ground that he was acknowledging his continued liability to pay for the maintenance of the 2 youngest children, now turns around and declines to contribute to their maintenance and education. And then he puts to one side the question whether there was raised judicata, and about 8 lines below that, towards the end of the line, says, but whether it is raised judicata or not, seems to me that there would be monstrous injustice if the husband, having suggested one construction of the deed in the old suit and succeeded on that footing, were allowed to turn round and win the new suit upon a diametrically opposite construction of the same deed. It would be playing fast and loose with justice if the court allowed that. So there one sees summed up the essence of the doctrine, in that case applying to a point of law, namely the construction of a deed. The next case I want to take you to is a Privy Council case from 1963 called Cockerill, and that was a case where an unsuccessful attempt was made to invoke the doctrine in relation to a default judgment which had been obtained against a hirer of machinery for rent that was owing up to a certain date. There was then a second action claiming rent owing from a later date, and in relation to the second action, the hirer then took a point which was that the whole transaction was void as being in breach of a money lending ordinance in Malaysia. And the Privy Council said when dealing with this, if your lordships will just give me a moment, if you go through page 53, at the very bottom of the page, last line, thus, despite the principle that limits estoppels where statutes are infringed, a litigant may be shown to have acted positively in the face of the court, making an election and procuring from it an order affecting others apart from himself, in such circumstances that the court has no option but to hold him to his conduct and refuse to start again on the basis that he has abandoned. Now, the concept that's introduced there, which one sees recurring throughout the cases in which I submit maybe of assistance in resolving some of the issues before you, in particular those concerning the relevance of legal advice, is the concept of election. So the party who's changed its position, or putatively changed its position, should have or has had to have made an election, which has then led to it taking the position in relation to the first decision. And one can see that same concept arising in the next case. Before we move on to that, I just want to show you how the Cockerill appeal was disposed of. It's at page 55 of the bundle, where Viscount Radcliffe, giving the judgment, said, the most that can be said, 4 lines down, the most that can be said against the respondent here is that it suffered or subjected itself to a judgment by default in the first action. Such a judgment is not incapable of giving rise to estoppel, but there's nothing in the attendant circumstances which would permit an estoppel based upon it, whatever its range, to exclude a plea based upon the money lending statutes. Now, the next case is Benedictus and Jalaram, decision of this court in 1988. The facts were of a slightly different kind, but one that may not in fact affect the underlying principle. What had happened was that in 1983, landlords, after the determination of a statutory tenancy, sought interim rent. And as we'll see in a moment, Lord Justice Bingham held that the tenants thereupon had a choice. If they had said, we're not in occupation anymore, then the landlords could have sought immediate possession, obviously. By asserting that they were in occupation, they accepted liability in principle for rent, although of course under the regime concerning protected tenancies, that then gave them potential rights to be granted a new tenancy. What happened was that 4 years later, the tenants changed their position and said they were not in occupation. And by then it was obviously...
They had been paying interim rent. They
hadn't been paying, don't seem to have paid rent, seem to have got away with that. but by the time they changed their position and said we're not in occupation in 1987, it was obviously of necessity too late for the landlord to claim possession for the period that had then elapsed. And if one goes forward to page 70, please, of the bundle, you'll see after the first break on the page, second line, it was pointed out, this is in the judgment of Lord Justice Bingham as he was, it was pointed out that when the landlords in April 83 issued their application for an interim rent, Jalaram had a choice. Either they could resist that application on the ground they were not in occupation, in which event the landlords could have sought possession and mean profits forthwith, or they could accept that they were in occupation and found on that fact to apply for a new tenancy, thus expressly or impliedly accepting their liability to pay an interim rent as and when determined. And the landlords would be to some extent protected financially. However, the application for new tenancy was finally decided. Jalaram chose to accept that they were in occupation, and then dropping down a couple of lines, having adopted that litigious position, which was not retracted for 4 years, Jalaram could not, the landlords submit, alter their position so as to deprive the landlords of their claim to interim rent. And the judge accepted that, saying that this was offensive against the principle that you can't approbate and reprobate, etc. Next break, Lord Justice Bingham refers to having been referred to various textbook passages on election of remedies, waiver, approbation, and reprobation. I don't think the present case falls within the letter of any of these doctrines or maxims, but each of the doctrines and maxims reflects the unwillingness of the courts to countenance inconsistent conduct by one party where this is prejudicial to the other. It's further to be remembered that in the present case, we're concerned not with statements made in the course of commercial dealing or negotiation, but formal statements made in the course of invoking the court's jurisdiction, statements which Jalaram now says, wishes to say were false. It seemed to me as to the judge, whether this rule is founded on public policy or justices between the parties, this cannot be permitted. If in the course of litigation a party A accepts the truth of an assertion of fact expressly or impliedly made by his opposing party B and founds on that fact formally to claim relief to which he would not be entitled if that fact were not true, and he knows if the fact is true or not, whether or not B is. And if the litigation is thereafter conducted on the basis of the truth of that fact, A may not thereafter assert the falsity of that fact and retract his acceptance of its truth, where the effect would be both to deny B a remedy, which would have been available to B had A asserted the falsity of that fact in the beginning, and to deny B a remedy to which A's acceptance of that fact entitled him. So in that case, the prejudice didn't arise from a judicial decision as such. The causal link between the first position taken by the tenant and the unfairness was not in the form of a judicial decision that had been reached on the footing of that first position, but it was simply an inexorable function of the lapse of time, that the remedy which was denied the landlord, the remedy of possession, by virtue of the fact that the tenant was asserting that it was still in occupation, was one that was no longer available to it. So that is how the Benedictus case was determined. And one sees again there the element of election, as Lord Justice Bingham said in the first of the paragraphs, the middle of the first paragraphs that I took you to about halfway down the page. Jalaram chose to accept that they were in occupation. And just to foreshadow a point I'll be developing in a bit more detail later on, we say, well, unless a party can show that in some way legal advice that he was given has deprived him, or had deprived him, of an effective choice, then there is no reason in principle why the content or fact of that advice, even if it's known to the court, should be of relevance in striking the balance. And following on from that, we say also that a party would therefore at least normally have to make a full and candid disclosure of all the legal advice it had received and its response to that advice in order to satisfy that sort of test. The next case is a very different case which contains some amusing vignettes for those of us who still remember the 1980s, and that's the Express newspapers case, which was Fleet Street at its very finest. The Express printed an exclusive interview with a celebrity, Ms. Pamela Bordess, and that, or what they claimed was an exclusive interview. And then the Today newspaper, no longer in existence sadly, ran a piece using that content, but making no reference to the fact that it had derived it from the Express. And the Express thereapon sued for breach of copyright and indeed obtained summary judgment from Mr. Blanco White QC, sitting as a deputy judge. Another paper owned by the same defendant was the Daily Star. And the Daily Star later on ran what it said was an exclusive based on an interview with a distant member of the royal family. And the Express thereon ran a piece which equally pirated what the Star had printed, and when it was sued for copyright, defended the Star's copyright claim, even though there was a mirror image pretty much between the two. The Vice-Chancellor, as he then was, Sir Nicholas Brown Wilkinson, at page 81 of the bundle, said this at letter C, and the detail for present purposes doesn't matter. He says, therefore, apart from the mirror image aspect of this case, I would have given the plaintiff, the Express, leave to defend the counterclaim brought by the owner of the Daily Star, so as to enable them to lead evidence, the plaintiff, to lead evidence of press custom relating to the reproduction of press articles with a view to establishing a defence based on implied licence granted by Today to the conduct of the plaintiff in the Daily Star, reproducing the story and quotations. However, I come back to the first point raised by Mr. Prescott for the defendant, counterclaiming defendant, which greatly impresses me. She says, the plaintiff applied for and obtained summary judgments against Today in relation to the Bordess article on facts which, in my judgment, are legally indistinguishable from the facts of the Ogilvy case. Mr. Burton, as he then was, sought to draw a distinction between the two cases on the grounds that the Today copying the Bordess article, etc., and he deals with that at the end of the paragraph. In my judgment, the fact that Today were more efficient pirates than the Daily Star has no legal significance. The fact is that if the defence is now being put forward by the defendants in relation to the Daily Star article, good defences to the Ogilvy case, they were and are equally good defences to the claim by the Daily Express against Today newspaper. And then he refers to some a statement in a witness statement from one of the editors. It says, next sentence, there's a principle of law of general application that it is not possible to approbate and reprobate. That means you're not allowed to blow hot and cold in the attitude that you adopt. A man cannot adopt two inconsistent attitudes towards another. He must elect between them, and having elected to adopt one stance, cannot thereafter be permitted to go back and adopt an inconsistent stance. And over the page, just below letter B, he says that the Daily Express is not entitled to put forward to inconsistent cases. So that shows us, again, the importance of understanding that the party that's changed its position had made an election, and it also, of course, decisively illustrates how a party that has changed its position can be shut out from a case which would otherwise be perfectly arguable, as the Vice-Chancellor held. The next case but one, which starts at page 90 of my Lord and My Lady's bundle, is a case of the US Supreme Court.
Very rare phenomenon, a unanimous judgment given by Ruth Bader Ginsburg.
Indeed, a phenomenon that we no longer seem to see in the cases that we read about. To be pedantic, Justice Souter didn't take part, presumably because of some prior conflict. And this, although I'll be corrected by those who know more, I believe is a part of the original jurisdiction of the US Supreme Court to determine interstate disputes. And the interstate dispute here, as the court may already have seen, concerned the boundary between New Hampshire and Maine. And there is a river called the Piscataqua River, which runs the final few miles of that boundary on the eastern side before the Atlantic Ocean in New England. In 1977, New Hampshire and Maine both agreed to and obtained from the Supreme Court then, in fact, with some dissent, although I'm not quite sure on what basis, a consent order whereby, ironically, given the fact we've just had a settlement of celebration of 250 years, the key feature that determined the boundary of these two states was nothing less than a decree of King George II in 1740, when I think Maine was still part of Massachusetts. And that set the boundary in, quote, the middle of the river, unquote. And while that may have seemed clear enough in 1740, by the late 20th century, it was no longer absolutely clear. But what was agreed by the parties, the two states, in 1977 and endorsed by the Supreme Court then, was that it meant the middle of the navigable channel of the river rather than the geographic middle. Now, in 2000, what had happened by then was that the US Navy, as you can see, if it's of any interest from the footnote on page 96 of the bundle, the US Navy had released some land on one of the islands in Portsmouth Harbour for development, and that was obviously valuable to whichever state had sovereignty over it. And so in 2000, New Hampshire changed its position as to what the boundary definition meant. And we can just go forward to see what they did. Page 99 of the bundle, the last break, where Justice Ginsburg summarised the position. So what they said in 2000, which was then considered in the later decision, was that the boundary from which the middle river of the river should be assessed was in fact the shore of on the northern side. And so Justice Ginsburg sums it up. New Hampshire's claim that the Piscataqua River boundary runs along the main shore is clearly inconsistent with its interpretation of the words middle of the river during the 1970s litigation. And even then there were different points of view, but as she says at the bottom of the page, last sentence, both of those constructions that were considered in the 70s located the middle of the river somewhere other than the main shore of the Piscataqua River. So the question was whether New Hampshire should be allowed to alter its position. And if you go back to page 97 in the summary at the start of the judgment, 4 lines down on the top from the top of the page, in the unusual circumstances this case presents, we conclude that a discrete doctrine, judicial estoppel, and that's just their label for the doctrine we're considering here, best fits controversy, and under that doctrine we hold New Hampshire is equitably barred from asserting contrary to its position in the 70s litigation, that the inland Piscataqua River boundary runs along the main shore. And then immediately underneath that, she cites earlier Supreme Court authority from the late 19th century, where a party assumes a certain position in a legal proceeding and succeeds in maintaining that position, he may not thereafter, simply because his interests have changed, assume a contrary position, especially if it be to the prejudice of the party who's acquiesced in the position formerly taken by him. And then over the page, halfway down the page, first break, courts have observed that the circumstances under which judicial estoppel may appropriately be invoked are probably not reducible to any general formulation of principle. And this passage is the one that was adopted by Sir Christopher Floyd in the later LA Micro case, who is also representing English law. Nevertheless, several factors typically inform the decision whether to apply the doctrine in a particular case. First, a party's later position must be clearly inconsistent with its earlier position, and then dropping down after the citations. Second, courts regularly inquire whether the party has succeeded in persuading a court to accept that party's earlier position, so that judicial acceptance of an inconsistent position in the later proceeding would create the perception that either the first or the second court was misled. Absent success in a prior proceeding, a party's later inconsistent position introduces no risk of inconsistent court determinations and thus poses little threat to judicial integrity. And a third consideration is whether the party seeking to assert an inconsistent position would derive an unfair advantage or impose an unfair detriment on the opposing party, if not stopped. Now, just pausing there and going back to the observation at the foot of page 98, the harm, if you like, that this doctrine is ultimately aimed at is the perception, or aimed at avoiding, I should say, is the perception that either the first or the second court was misled. So what one is looking at, therefore, is the risk of third parties, of the public, seeing the system being gamed. It's not necessary to decide which of the inconsistent positions is correct. It's not necessary to say whether either position has been taken in bad faith. It's concerned with the effect on the public perception of justice and the integrity of the system. Going forward to see how Justice Ginsburg resolved it, at page 101, first break on the page, New Hampshire also contends that the 1977 consent decree was entered without a searching historical inquiry into what that language, the 1740 language, middle of the river, meant. According to New Hampshire, says Justice Ginsburg, had it known then what it knows now about the relevant history, it would not have entered into the decree. We do not question that it may be appropriate to resist application of judicial estoppel when a party's prior position was based on inadvertence or mistake. Where I'm persuaded, however, that New Hampshire's position in 1977 may fairly be regarded as a product of inadvertence or mistake. Pleadings in the, and then that's the earlier case, the lateral marine boundary case, show that New Hampshire did engage in a searching historical inquiry into the meaning of the middle of the river, and then she cites from what was said before. And then over the page, at page 102, some helpful, in my submission, observations in the first break of the page. Nor can it be said that New Hampshire lacked the opportunity or incentive to locate the river boundary at Maine's shore. In its present complaint, New Hampshire relies on historical materials, primarily official documents and events from the colonial and post-colonial periods, that were no less available 25 years ago than they are today. And New Hampshire had every reason to consult those materials. So she goes on at the top of page 103 to say that considerations of equity persuade us that application of judicial estoppel is appropriate in this case, having convinced this court to accept one interpretation in the middle of the river and having benefited from that interpretation, New Hampshire now urges an inconsistent interpretation to gain an additional advantage at Maine's expense. In other words, to gain a better outcome, because if the boundary was shifted north, New Hampshire would get more of the boundary territory, frontier territory. And over the page at 104, first break on that page, what has changed between 1976 and today is New Hampshire's interpretation of the historical evidence concerning the King's 1740 degree. And that wasn't enough. And so they conclude at the bottom of the judgment that judicial estoppel bars New Hampshire. So that's very similar in my submission to saying, well, our legal advice has changed and it wasn't good enough. New Hampshire had the means, if it had chosen in 1977, to look at the evidence that it later wanted to rely on. Reasonable diligence, in other words, would have allowed it to ascertain the source materials for its later argument, and that feature was fatal to it being allowed to rely on its new position or advance a new position. Put another way, nothing had happened to deprive New Hampshire in 1977 of an effective choice as an effective election as to what to do. That then brings us to the LA Micro case at 105. The facts are a little bit knotty. I'll try and paraphrase them as briefly as I can for present purposes. There were two American businessmen who had a company which is referred to as Inc., LA Micro Inc., and in 2004 they entered into some form of joint venture arrangement with a British businessman, a Mr. Bell, and a company called Limited, LA Micro Limited, was formed. And there was a shareholding on both sides, which was the essence of the dispute, and also trading arrangements. In 2010, the two American businessmen fell out very badly, and as was found in two successive English proceedings, there was at that point a disavowal by one of the American businessmen, a man called Mr. Frankel, of any interest that he had in the UK company. So he disavowed any interest at that point. You, Mr. Bell, go your own way. I don't want anything more to do with it. And that was that. But in 2015, notwithstanding that, Mr. Frankel brought proceedings in England for a declaration that he personally owned 25.5%, being half of the 51% that was the US share of the UK company. And that was successfully defended by Mr. Bell. Mr. Bell obtained a decision from Miss Tipples, as she then was, you see, sitting as a deputy judge, dismissing Frankel's claim. And in the course of that, Mr. Bell said that the 51% was always held by the US company, by Inc. Just for your note, the issue in the 2015 proceedings was what had been agreed about the UK company back in 2004. One can see that in paragraph 28 at page 115 of the bundle between letters C and E, in the fourth line of that paragraph. Later proceedings, and those proceedings were the ones before the Court of Appeal, were then brought by Mr. Bell and the UK company in 2020, and he claimed a declaration that the shares in the UK since 2010 had been held by the other US businessman called Mr. Liampert and himself in a 50-50 split. So that related to ownership since the falling out and the disavowal in 2010. And the defendants to the 2020 claim, which was Mr. Frenkel and the US company, resisted the claim. And they also, on its merits, but they also took a preliminary point saying, well, look, Mr. Bell, you've changed your stance, because in the earlier proceedings, you were saying at all times that the US shareholding had been held in the UK company, had been held by the US company. Going to page 114 of the bundle, please, at paragraph 24, in the judgment given by Sir Christopher Floyd, having introduced the New Hampshire case in the previous paragraph, he summarises and essentially paraphrases the statements of principle from Justice Ginsburg at pages 98 to 99 of our bundle, which I took you to. And then at 25, he says that the authors of Spencer Bauer consider there's no reason to suppose that the law of England is different from that held to the law of the US. No party suggested that this was wrong, and I agree. It's clear, therefore, that this form of estoppel by conduct is one which is approached by means of a broad merits-based assessment. It's not constrained by strict rules, as, for example, issue estoppel. The matters to consider include, but are not limited to, those enumerated by Justice Ginsburg. It is material to ask the question whether it is apparent that the earlier decision was obtained on the footing of or because of the stance taken by the party in the earlier proceedings. Absent that factor, whilst the change of position may affect the credibility of the party or the witness concerned, there will not be an impression that one or other court was misled. One notes that a very similar formulation to that of Justice Ginsburg was misled into giving its decision, so that the administration of justice risks being brought into disrepute. And then he goes on in the rest of that page and the next page to analyse the question which is identified in the sentence just before the one I read, this, it is material, etc. The question of how the earlier decision was obtained. And his conclusion at paragraph 33 was that the suggestion that Mr. Bell and UK succeeded in the 2015 proceedings in relation to the terms of the 2004 agreement because of the stance which Mr. Bell took on the continued ownership of UK after 2010 seems to me to be far-fetched. In other words, he finds that there was no causative impact of the inconsistent position which Mr. Bell had taken in the earlier proceedings. That wasn't any part of the result that had been obtained in those earlier proceedings. So in a nutshell, therefore, there'd been zero contribution of the changed position to the earlier judicial decision. The next case I want to take you to is another decision of this court in a case called Malik against Malik, and we've got that was a second appeal in this court. We have, but I'm not going to take you to it, the decision of Mrs. Justice Bacon at the first tier of appeal, but I'm going to ask you to go to the judgment of Lord Justice Zaccaroli in this court, and that starts at page 166 of the bundle. Again, the facts were a little convoluted, but it concerned a flat in Knightsbridge, which had been bought as a family property for a Bangladeshi family, but for a very long time, one brother, Vetcare, spelled V-A-Q-A-R, had lived there to the exclusion of all other family members, although his wife also lived there. And as long ago as 1987, possession proceedings had been brought, and they then remained stayed for a quarter of a century. In 2012, those possession proceedings came in front of Mr. Jarman QC sitting as a recorder, and Mr. Jarman decided that he would not lift the stay on those possession proceedings, and he did that because of the impression that had been given to him by Vetcare in discussion with him, Mr. Jarman, that he, Vetcare, would not be claiming adverse possession. In other words, wouldn't be saying because of the fact that I've been there for the last 25 years, it's now too late to get me out anyway. And because of that, Mr. Jarman considered that the cleanest course was just to allow those seeking possession to start a new action. But lo and behold, in relation to the new action, Vetcare did then turn round and claim that he had rights deriving from adverse possession. And the question was whether he was entitled to do that. If we go to page 173, starting at page 172, Lord Justice Cockerill, under the heading, and you'll see why he has that heading in a moment, abuse of process stroke estoppel by conduct, refers to the law. He cites LA Micro, and in turn the New Hampshire case. Some other cases were cited. 35, he says, Lord Justice Cockerill says he does not necessarily consider those cases in detail. It's unsurprising that courts have expressed the applicable principles in different ways and emphasise particular elements on different occasions.
Mr. Bayard, you know this case certainly better than I do. There's quite a long and helpful headnote on page 167. And
yes, my lord.
Does that have all that we need to know, or do we need to know more?
I'm going to confess that I haven't fully absorbed the headnote. I'm just going to be 2 minutes taking you to it. On a brief glance, I think it will be helpful just to look at a couple of passages in the judgment itself.
Yeah. Okay.
And apologies that I'm not able to give your lordship a straight answer to a perfectly fair question. 36, Lord Justice Cockerill makes the point that this can readily be seen as a species of abusive process. 37, and this is relevant obviously to both sides' arguments on the appeal. It refers to the approach that this court should take when considering what a judge at first instance has done when deciding whether or not to apply this doctrine. Very familiar territory, obviously, Lord Justice Thomas in Alding. In relation to the decision that at first instance there, which was by Judge Gerald, His Honour Judge Gerald, that had been set aside by Mrs. Justice Bacon, and the Court of Appeal then in turn disagreed with her, reversed her and reinstated Judge Gerald's decision. Judge Gerald's view leaves little room for doubt about what he really thought, as they say. If we go to page 177, at point 4, just below letter D, having referred to the exchanges that Vetcare, the brother in possession, had with Mr. Jarvis in 2012, he concluded that the above reveals a masterpiece of dissembling and manipulation. In other words, Vetcare had managed to duck and dive to the questions from Mr. Jarvis, QC, with not absolutely pinning himself to the mast on the transcript, but creating an impression. And point 5 below letter G, Judge Gerald concluded, taking all these factors into account, in my judgment, it's an abusive process for Vetcare to now seek to advance a case for adverse possession. If you go to 52 on page 178, Mrs. Justice Bacon nevertheless held that Vetcare was not precluded on the grounds of abusive process from bringing his claim for adverse possession, because it wasn't possible to identify from his exchanges with Mr. Jarvis in 2012 a clear representation by Vetcare, bottom of the page, paragraph 55, Mr. Mumby, who was for the claimants seeking possession, submitted that Mrs. Justice Bacon was wrong to conclude that it's necessary to establish objectively whether what Vetcare said at the 2012 hearing amounted to a clear and unambiguous representation. One can see over the page, paragraph 61, that Mr. Jordan, it's summed up at 60, said there was a need for a clear statement by the party who's changed its position. At 61, Lord Justice Cockerill doesn't accept that submission. He refers to the broad merits-based assessment. 62, the key questions in this case are whether Vetcare has adopted clearly inconsistent positions and whether Mr. Jarvis on the prior occasion acted on the footing of the position that Vetcare then adopted. As a matter of principle, there's no reason to impose a further requirement that Vetcare expressed his earlier position by way of an objectively unequivocal statement. The party sets out to persuade the court that it holds a certain position, the court is so persuaded, and the court acts on the footing that the party holds that position, then that creates the risks of unfairness and of bringing the administration of justice into disrepute, which underpin the estoppel by conduct principle. And that's enough. But there was a further issue that had to be considered, which one sees starting at 66 on page 180, that Judge Gerald found that Vetcare's statements brought about or strongly influenced Mr. Jarvis's decision. So that's what's the strength of the causal link that's required. And Mrs. Justice Bacon held at 58 that Mr. Jarvis's understanding of Vetcare's position was undoubtedly a material reason for his decision. One notes, by the way, that's the same finding that Judge Bird made here. And this was sufficient to engage the principle. She rejected the contention that the statement must be a but-for cause of the decision, noting that according to the Court of Appeal in LA Micro, it is sufficient that the position taken by the relevant party was a reason for the decision. And she noted that where the decision is a balancing exercise, reached on the basis of an assessment of a number of different factors, it may be impossible to isolate any one of those factors as playing a decisive role. In such cases, what's required in my judgment is that the statement was a material factor in the decision. Nothing is then said by Lord Justice Zaccaroli to diminish or disagree with that statement of principle by Mrs. Justice Bacon. The argument that was run by Vetcare's counsel was that it could be deduced from consideration of all of the circumstances that, and one can see this summed up at the end of 73, just below letter D. It was a paradigm case to strike out from which it follows that Mr. Jarvis could only have refused to lift the stay. In other words, Mr. Jarvis's decision not lifting the stay on the original 1987 proceedings was inevitable. But that was one which, as you can see, Lord Justice Zaccaroli disagreed at the start of 74 and at the start of 76. It says it's impossible to tell how the balancing exercise would have been carried out. So his conclusion ultimately at 78 was he's not satisfied that the only decision Mr. Jarvis could have reached, even without Vetcare taking the position he did, was to refuse to lift the stay. So whereas in LA Micro, Sir Christopher Freud had concluded that it was possible to be confident that there was, as I put it, zero impact of the earlier position on the earlier decision. That was a conclusion that wasn't possible in the Malik and Malik case. So those are the authorities which I propose to take you to at this stage. I'll have a couple of others at the end of my submission. But I want to turn now to the causal impact in this case. And I'm going to ask the court, please, to take up the supplemental bundle. So the basic chronology, just to remind you, Mr. Lay sold the company, which is called EDD, Easy Direct Debits, in October of 2020 with warranties of a familiar kind in the SPA. And he remained as the managing director or CEO of EDD in place. The buyer was IVL, also IVC.
We have a chronology at tab 3 of the core bundle.
Yes, you do,
Yeah.
thank you. And after a series of disagreements, as you've seen, Mr. Lay was dismissed in May of 2023, and he thereupon brought employment tribunal proceedings, and as you've seen, those then led to a hearing on the 30th of June 2023, at which he sought interim relief, which, as I'm sure the court well appreciates, is available in certain limited circumstances as an order from the employment tribunal, where, among other things, the claimant is considered likely by the tribunal to have been dismissed because he made a protected, i.e. public interest disclosure, so whistleblowing. In opposition to that, there was filed a witness statement, which we can see at tab 16, starting at 118, from Vanessa French, who was the general counsel of IVL.
Sorry, which tab?
16, my lady.
Thank you.
So she's the GC, and at page 120, paragraph 8, she says, the second respondent, so that is IVC, had bought a business which was not and was not required to be regulated by the FCA. According to the SPA and disclosures, the second respondent understands that there is no legal or regulatory imperative for the first respondent to become FCA regulated. It can rely on the support of regulated firms, or it can rely on exemptions from regulations. The claimant clearly knew this to be true. He already warranted that this was true, as referred to above. And as the court, I'm sure, appreciates, but for your note, there's a clear explanation in paragraph 14 of our skeleton argument, consisting of citations from Judge Bird's judgment. There's a distinction between what was called the direct model and the indirect model, these being subsequently introduced labels, but helpful labels. The indirect model was the one that pertained at all times up to and including completion, and that was where the direct debits were handled by third-party companies who are well-known companies, one called Go Cardless, and the other called Bottom Line. So they are then the ones that do all the actual processing, and I'm not using terms precisely here. EDD, the company, provides some software, a sort of dashboard, it's been called in the evidence, which allows vet practices to then use that facility in order to set up direct debits from their customers, from pet owners who want to pay a monthly subscription in order to obtain basic veterinary cover. That's what the business essentially does. So that indirect model then involves third parties handling and processing. A different model, which wasn't in play until after completion, is the direct model. That model was one which was sought to be introduced, so not therefore connected with the warranties, which obviously only apply to the business up to the date of completion. But under the direct model, and this was of particular relevance to the very large number of customers which were who belonged to practices, veterinary practices under the IVC umbrella, IVC being a private equity-backed consolidator that's acquired veterinary practices around the country. And under that model, it would be EDD itself which would carry out the processing of the direct debits, and it would be able to do that, or might be able to do that, by using a BACS number that belonged to its bank, in this case NatWest. So that's a very simplified description. As I say, it's present, it's set out in more detail in paragraph 14 by skeleton quoting from Judge Burr.
And am I right, Mr. Bayard, that the notice of warranty claims of the 28th of October 2022
Yes,
alleges breach of warranty in relation to the indirect?
yes, my lady, absolutely. And that is, just again to foreshadow a point which is probably already clear to my lady, that is part of what I say is the background of election, that this company, IVL, made a choice, knowing that there was plenty of room for argument, to put it mildly, about what had been going on and the legal consequence of that. So that was Miss French's position in her witness statement before the Employment Tribunal, and then we have a transcript of the hearing, which is in my submission revealing. That's at tab 20, my lord, starting at page 169. And on that occasion, the claimant, Mr. Lay, was represented by Mr. Strelitz, who sits behind me, and the defendants were represented by Ms. Sengupta, KFC. And you can see from the top of page 170 that the employment judge, Judge Cadney, says at line 20, he's going to get on with the pre-reading and he's going to see them a little later. And then halfway down the page, the court resumes. It seems to be a remote hearing. And then there's a summary by the employment judge of what he perceives to be the respondents, the defendants' case. So perhaps unusually for these cases, one actually gets the sort of direct insight, rather like a novelist giving us the sort of first-person view. And
this is a type of hearing for which 1 day is allotted, and effectively the statute prohibits adjournments. It all has to be done on the day, doesn't it?
yes, yes. But notwithstanding those strictures, Employment Judge Cadney puts forth his interpretation.
Yeah.
And as you'll see what that is, and that it's adopted, but I'm just going to take you through the detail, if I may. He says he's had the opportunity of reading, and at line 28 on page 170, it appears, well, he said, line 27, Ms. Sengupta will forgive me and correct me if I'm wrong, but it appears to me the reasons the respondents set out as to why I should not make an order for interim relief can be summarised relatively briefly, and then he refers to a number of factual assertions which feed into the legal questions. And at line 33, secondly, they assert that there was no legal obligation for the first respondent to change its business model, that it could perfectly lawfully and legally continue to operate as it had. If either or both of those propositions is correct, then it raises the question of whether the claimant's disclosures of a breach of the SPA and or a breach of the regulatory requirements could have been made in the reasonable belief of the claimant. So, in other words, in order to get off the ground, you've got to show that there's a protected disclosure, there's got to be a reasonable belief of the employee that he or she is making a disclosure in the public interest. And the employment judge points out that if the business could perfectly lawfully and legally continue to operate as it had, then that raises the question whether those disclosures by the claimant could be ones that were protected disclosures. And then at line 6, he says, there's then the causal link between the dismissal and the protected disclosures, if they are protected disclosures. So that's a separate issue. The respondents say that they've set out an arguable, at least, basis for dismissing the claimant, and that was a basis to do with some alleged conduct of the claimant, which had nothing to do with regulation. And so he concludes at line 18, appears to me that that is the essence of the respondent submissions, and he asks Ms. Sengupta whether that's a fair summary, and she says it is, it's a very fair summary. And then he goes on to say, it seems to me that at the end of the day, your job, Mr. Strelitz, is to persuade me that those points are not well made. So one can see already at that stage, and then reflected in the reasons for judgment, the impact that the position being taken is having on the mind of the tribunal. The reasons for the decision are at the next tab, starting at tab 21, page 175. There are 2 pages which we're not concerned with, where the employment judge records and comments on the background to him being asked to produce these written reasons under an order of Judge Pelling.
Well, I should tell you, it may not affect the outcome of this appeal, but I'm concerned by it. How was it that Judge Pelling made an order which it seems he has absolutely no jurisdiction to make? And what was the employment judge supposed to do? Supposed to say, you have no jurisdiction to make this order. What are you going to do? Send me to prison for contempt if I refuse?
Well, it's a very unhappy situation, but I'm going to be candid and say I can't assist your lordship on that at all. I wasn't involved in that part of the proceeding. I've come in to deal with the appeal. And,
well, if Mr. Strelitz can help at some point, I would be interested to know for the narrative. As I say, I don't think it affects the outcome of today, but it's very unusual to see High Court judges making orders which they have absolutely no jurisdiction to make.
My lord, I'm not in a position even to, I'm not disputing what your lordship says, but just for the avoidance of doubt, because I haven't considered that angle, I'm not able to say even whether there is or is not jurisdiction, but please don't consider that I'm trying to pick a fight with your lordship. I understand the problems, and one looks at this and thinks of sort of 19th century disputes where courts of equity would make orders against courts of King's Bench, etc. And it's obviously a situation which we're supposed not to have in not just the modern era, but any era. So I'll do what I can over the short adjournment to try and inform myself.
Yes.
But my lord, I do with great respect agree that it doesn't have a bearing on the decision that you're asked to make today. What does have a bearing is the reasons for the decision, and one can see at page 178, top of the page, paragraph 10, the issue is the claimant likely to succeed? And that paragraph 12, Judge Cagney sets out further authority that I'm sure my lord will be familiar with, which I paraphrase slightly inaccurately as meaning you've got to show it's highly likely that you'll succeed. And so that was the hurdle that Mr. Lay, the claimant, had to meet. And then going forward to page 180, paragraph 21, respondent submissions. The respondent submits there are a number of fundamental aspects of the claim, all of which are in dispute. And then 23, there are factual disputes underpinning the claimant's assertions, which mean it's not likely that the tribunal, which ultimately hears the case, will conclude that he'd made disclosures of information tending to show any breach, or that disclosure was in the reasonable belief of the claimant in the public interest. And at the bottom of the page, the last line says, secondly, they contend that not only did the claimant assert that the existing operating model of the first respondent was in accordance with regulatory requirements, but that was an entirely accurate assertion. There is therefore a live issue as to whether the claimant will be able to demonstrate that any of the disclosures on which it relies tend to show any breach falling within 43B and are protected disclosures. And then paragraph, and one sees at the end of 24, they say it's an entirely personal dispute. That's 2 lines up from the bottom. And the conclusions, so there's then set out the submissions made by the claimant, including at the top of page 182, paragraph 27. He contends firstly that the dismissal was self-evidently procedurally unfair. There was no investigation, including any input from him. There was no disciplinary hearing in any meaningful sense. He wasn't offered the right of appeal. So it was a case where he was called in and told, you're being dismissed. And pausing there, one can see that, just as a general observation, where you've got a potential whistleblowing case, if you've got an ostensible reason for dismissal which appears in that way, that may provoke some concern and some suspicion. Paragraph 28, my conclusions are that I fundamentally accept the respondent's submissions, which is summarised on the previous 2 pages. It is by no means impossible that the claimant will be held to have made one or more protected disclosures, but on the information before me, there are live issues of fact and law, which mean it's not possible to say that it is likely in the sense set out above that he will do so. In other words, that he will be held to have made one or more protected disclosures. So that's the first ground of decision. And the second ground of decision is that whilst he accepts criticisms of the procedural flaws in relation to dismissal, it does not follow my judgment that the tribunal which ultimately hears the claim will reject the proposition that the reason given for dismissal was the genuine reason. So those are the 2 bases for the decision of the employment judge.
So the claimant had to succeed on both points. To get interim relief, you have to show that whistleblowing was the reason or principal reason for dismissal, and that that's the second. First, that there was a protected disclosure, and secondly, that the protected disclosure was the reason or principal reason for the dismissal. Otherwise, you don't get interim relief. The dismissal may be procedurally hopelessly unfair.
Indeed.
But just as an ordinary unfair dismissal case,
no,
rightly or wrongly, some people would say wrongly, you can't get interim relief.
Indeed. Indeed, that's the legislative framework that we have. But just to confront, as it were, what may be underlying my Lord's observation, even if one were to say that the inconsistent position only affects the first of those 2 grounds, and I accept they're cumulative in terms of what an applicant for interim relief in the ET has to show, even if it's only one of the grounds that's affected, the rationale of the doctrine that we're dealing with here, the abuse of process doctrine, is still engaged, because if a court says, I'm rejecting your case on each of 2 limbs, either would be sufficient, you've still got a rejection on the first limb, and that then creates, or is capable of creating, a risk of the perception later on that the courts talk about, that the perception that's damaging to the administration of justice if a later decision is then reached on an inconsistent ground to that which was put forward. So that's why we say that the administration of justice is just as much affected if a decision is reached on 2 grounds, but only one of the grounds ex hypothesi is affected by the inconsistent position. I'd also dispute, with respect, that premise that in my submission, the respondent's position before the employment tribunal was, in a sense, a package, and is in this sense that the plausibility of an employer's stated reason for dismissal is evidentially bound up with whether there has been a protected disclosure. So if you, the employer, suddenly dismiss somebody without any sort of normal procedure, and you're a perfectly well-resourced and professionally operated business, you obviously know the rules, but you don't hold any proper sort of investigation, there's no semblance or shadow of a disciplinary proceeding. And if that follows some prior interactions concerning the legality of the operations of the business as a whole, then that will inevitably raise suspicions about the employer's real motive. And it's the classic case that somebody who whistleblowers and then the employer goes around and looks for a problem, you know, let's find something to do with their expenses. It does happen. And an employer, therefore, if the employer can come along to the tribunal and robustly assert, to use a colloquialism, nothing to see here, there is literally no problem with the legality of our operations, that's going to put them in a much stronger position overall and is going to assist them in pushing back against the contention that the real reason for dismissal was the prior disclosures rather than the ostensible stated reason.
But it's stronger than that, isn't it? Because they're not just saying no problem here, they're saying no problem here, and Mr. Lay accepted at the time that there was no problem. Look, he's even given us a warranty to suggest there's no problem.
Yes.
How can he possibly be whistleblowing?
Exactly. So they're putting forward a total picture, but it's all connected, and they are asserting that Mr. Lay said what he believed to be the case and warranted it, and at the time in the contract, and that is the case. And so there's simply no reason why we should have been concerned by any disclosures that may have been made subsequently about the lawfulness of our operations. And therefore, when we came to dismiss him with this procedurally or non-existent dismissal process, whatever criticisms may be made of it, it's not something which was the product of his disclosures to us. And so I accept neither the major premise nor the minor premise that Mr. Totsi maybe will be putting forward. We'll wait and see as to what happens where you have two grounds of the earlier decision. I'm saying that even if one of the grounds is wholly unaffected by the inconsistent position, that doesn't matter. But in any case, this was not such a case. So if I can now take you to the judgment itself, and leadership to be very patiently listening to me talk about the appeal. It's referring to the judgment under appeal, but can I now make that good?
Yes.
Obviously, that's at tab 5 of the main bundle. At paragraphs 5 and 6, he summarises the two models, and reiterating what my Lady Justice Cockerill noted a few minutes ago, paragraph 6 on page 44. For completion, EDD employed the indirect model, and you've got two payment service providers, or PSPs, Go Cardless Limited and Bottom Line Technologies Limited. And then he introduces the SPA, which in the conventional way had a down payment and then deferred consideration and an earn-out. Paragraph 8, a warranty that the business had been conducted in accordance with relevant laws. And the paragraph 9, the casus belli, the second earn-out payment hasn't been paid, and so the claim brought by my clients is a debt claim. Paragraph 10, the defendant asserts that the claimants are in breach of the conduct warranty in that they were operating EDD at and before completion in a manner that contravened the Payment Service Regulations 2017. Counterclaim for damages, setting that off against the claimant's claim, and then paragraph 11 sets out the detail of the defence and counterclaim. Paragraph 12 until about March of 2021, so for 5 months or so after completion, EDD continued to operate via the indirect model, and thereafter it operated a hybrid model, dealing with some veterinary practices on the indirect model and some on the direct model. And then the direct model in paragraph 13, as I mentioned earlier, is one which related to the new payments, as it's put on the forthcoming, for practices owned by the defendant. So that's referred to sometimes in the evidence and in the documents as the IVC vets, those who were already within the IVC stable. And then just going, if I may, to see how it's resolved at the end, and then we'll come back to look at the evidence such as it is that Judge Bird relied on to support his conclusions. His conclusions are all set out on page 52. First of all, at paragraph 61, he's satisfied, and this goes to the first of Justice Ginsburg's tests. I'm satisfied that clearly inconsistent approaches were adopted in June 2023 before the ET and in these proceedings. In June 2023, it was asserted that EDD's indirect model was lawful, and then he cites some paragraphs of the grounds of resistance in the ET and paragraph 48b of the ET skeleton argument, which makes that clear. Just to give your lordships for your note, but I won't ask you to turn it over, your lordships, for my ladyship. The paragraph of the ET skeleton is that you can find at the supplementary bundle, tab 18, page 152, and that cites paragraph 8 of Vanessa French's witness statement, which I took you to a few minutes ago. Judge Bird continued, it's immaterial that the grounds of resistance were subsequently amended. The position adopted in these proceedings is that the model was unlawful. So he there succinctly, and we say correctly, defines the contradiction. 62, he says that inconsistency of this kind is not enough to prevent a change of position. In other words, it's not enough on its own, and of course no one says it is. 63, the real question is this: does the change of position amount to an abuse of process? The outcome of that question requires me to consider all the circumstances of the case, including the link between the first adopted position and the outcome of the first hearing, and why the first stance was taken. In my judgment, it's also useful to consider why the second stance was taken. So he then goes on to deal with the link, and in paragraph 64, he says the EC decision was concerned with the apparent protected disclosures and the question of whether EDD was unlawfully carrying on a regulated activity. At the time, both the indirect and direct models were in use. ET found in effect that the direct model, which required authorization, could be dropped, and the indirect model was not a regulated activity. I accept that the position adopted by EDD and IVL before the ET was a material factor in that decision. And dropping down just as the last paragraph on the page, first sentence, he repeats that conclusion. I accept that the stance before the ET was a material factor in Mr. Lay not being awarded the interim relief he sought, and so not being reinstated. Now, just pausing there, therefore, one sees in terms of the New Hampshire criteria that clearly the judge has made a finding of fact. There's a clearly inconsistent position, and he's also made a finding that has had an impact on the judicial process. So thus far, Mr. Lay
is doing quite well, but where it goes wrong for him is, we can see at paragraph 65 through to 67, why did the defendant take the first stance before the UT? In my view, and on the evidence I've considered for this application, the defendant advanced that position to the ET because that was the legal advice that it had at the time, based on the factual background it was then aware of. 66, why has the defendant now changed its stance? In my view, the change of stance on the evidence I considered came about because the advice changed. And then 67 shows us the impact of those conclusions as to why the different stances were taken. Would allowing a change of position lead to an unfair advantage to the defendant or an unfair detriment to the claims? In my judgment, once it is understood that the different positions were adopted because of a change in circumstances, that is, a change in the factors understood and a change in the legal advice given, it would not. The lawfulness of EDD's pre-completion business model is key to the outcome of the present claim. In my judgment, the administrative justice is best served by determining that issue.
What's the change of facts as understood that he's referring to there?
The change in facts is completely unclear. And that's the point I'm coming to, that neither the facts or perceived facts are spelt out by Judge Bird, and nor, of course, is the legal advice identified. It's put in terms, purely conclusory terms of the utmost generality.
It would be a bit difficult to know what the legal advice was since privilege wasn't waived.
Indeed, it's difficult for anybody to have known. We don't know, and Judge Bird, with great respect to him, doesn't begin to actually point to any particular advice given, any particular content, which would enable him to make either of the findings that he makes in paragraphs 65 and 66.
But in any event, you say none of that matters because if you apply New Hampshire properly, it doesn't matter if the advice changes.
Of course, we do. So again, both the major premise and the minor premise, I always forget which is which, are wrong in the judge's syllogism. So that in a nutshell is the problem, that the judgment is wholly unspecific in its conclusions and in the way in which it derives those conclusions from the evidence. But I should now just take you back to see if one can engage in an exercise of reconstructive surgery. Even assuming that were proper to do, we say with whatever skill Mr. Toxie will seek to conduct that exercise, he will unfortunately fall short. So just going back to the judgment at page 46 of the bundle, in paragraph 17, the judge gives himself a helpful or partly helpful self-direction, but one which he rather loses sight of later. There's an issue about the degree, so the subheading I should have mentioned, what IVL knew about the lawfulness of the EDD business. 17, there's an issue about the degree to which advice was shared. The evidence on the legal advice is not always easy to follow. It's presented in the evidence as a dense 8-page chronology presented in a table, and it's not complete because the defendant has asserted legal privilege in respect of some advice. Now, just for your note, we'll be coming to it in a moment, but the way that the advice, or that such advice as there was put forward, was by a table in paragraph 12 of a witness statement from Stewart Murdoch, who is a partner in the law firm DLA Piper, and also, so he informs us, what he calls the supervising partner on this claim. His evidence or extracts from his witness statement before Judge Bird are at tab 27 of the supplementary bundle, starting at page 254. I'll be taking you to those in a moment, but let's look, if we may, first at how Judge Bird dealt with it. And I'm simply giving you the reference, and the table itself is at page 255. So that's the table that Judge Bird refers to in the third sentence of this paragraph. And he's correct, although perhaps not clear enough with respect, when he says the defendant has asserted legal privilege in respect of some advice. In fact, the only advice that Mr. Murdoch puts forward is advice that was given by Fox Williams, a different law firm, not to IVL, but to EDD. So what happened was that Mr. Lay, as the CEO of EDD, engaged solicitors to advise that company, and those solicitors were Fox Williams, and the partner leading that, whose name comes up, was somebody called Chris Finney. So that's the advice which Mr. Murdoch tabulates. Mr. Murdoch makes no specific reference whatever to any advice received by IVL, even though he makes plain that he himself has been advising IVL since September 2022, and that, again, just for your note, is paragraph 8.4 on page 257 of the supplementary chronicle. And again, we'll see that the defendant was extremely careful to avoid doing anything, either to disclose what advice it received or to say what view it took of the facts, having received that advice and the legal outcome, or to say anything which might be, in its view, considered as a waiver of advice that it had received. So Judge Bird notes that there's a table that it's not easy to follow, but it already perhaps has been somewhat distracted by failing to perceive that he hasn't received any evidence about the legal advice given to the actual party that we're dealing with. And he goes on to say, advice was often subject to caveats and often based on an incomplete or potentially incomplete factual background. The key in my judgment is what advice the defendant had at the key times when it presented its case to the ET and when it pleaded its present case. Well, even if in principle that is the key, the difficulty is that
he's got no evidence of it.
Yes,
he's got no evidence at all as to what advice the defendant had. He's got some advice. He's got evidence as to what advice was given to EDD, which is the target company, which may or may not have been supplied to the defendant.
Yes, exactly. So it's to adapt the metaphor. It's a lock without a key because he hasn't been given the information which will allow him to say what advice did the defendant have. Then one can see on the 7th of paragraph 19, he refers to advice given by Mr. Finney of Fox Williams on the 7th of October, and Judge Bird sets out in italics Fox Williams' working assumption that the indirect model is lawful.
Where's that?
Para 19, my lord, on page
19.
Yes.
Yes.
So Fox Williams's working assumption stated on the 7th of October 2022 is that the indirect model is lawful because every regulated payment service is provided by the FCA authorised payment institutions, Go Cardless and Bottom Line, and not by EDD. We haven't been instructed to check whether this is right, but it's a reasonable assumption, and I can't recall seeing anything that might suggest it's flawed. So that is the advice that's given on the 7th of October. And if I could just ask my lord and my ladies to, while leaving that open, to go to the supplemental bundle, page 46, tab 9. You'll see this email starting starting at the bottom of the page, about an inch up, on the 7th of October at 13:19, from Mr. Finney, sent to Mr. Lay, with the heading Consolidated FCA Regulatory Advice, and he says he's writing A, summarise, and where relevant update the advice I've already given, and B, give the further advice I'm about to give. He says it's a long email, and then over the page, number 1, the non-IVC vet business, and then there follows the paragraph that Judge Bird quotes in what I've just read you at paragraph 19. So the working assumption is that it's lawful, and Mr. Finney says it's a reasonable assumption. He doesn't recall seeing anything that might suggest it's flawed. And here, as with other matters, for what it may be relevant, any suggestion that somehow there was some secret channel of different advice that had been given by Fox Williams, and or that such advice was being concealed, has to be read in light of the fact that here you've got the partner in Fox Williams saying in terms, this is my assumption, it's reasonable, I haven't seen anything to suggest it's wrong. So whatever he may have been concerned about it at an earlier point, by the 7th of October, that's his position. And then just going back to page 46 of the bundle, above Mr. Finney's email, one can see that Mr. Lay, on the Friday, a couple of hours later, or 2 hours later, same day, 7th of October, forwards it to Mr. Gillings and Ms. Simpson, who are two IVC executives, who are the IVC nominees on the board of directors, or were the IVC nominees on the board of directors of EDD. So there were three, after the purchase, there were three directors, Mr. Lay, and then two IVC people, Mr. Simpson, Mr. Gillings, sorry, and Ms. Simpson. Mr. Lay, therefore, completely transparently passing this on. And one can see, just going back to where we broke off, that the difficulty for IVC was not the, on page 47, the first point, that's to say the non-IVC vet business, what we're now calling the indirect model, not the thing, in other words, or the state of affairs that existed at the date of completion and which was acquired by IVL or IVC. The problem was point two, the IVC vet business, because Fox Williams say our analysis shows that EDD provides regulated payment services to the IVC vets and their customers. He says there's a credible argument that EDT is entitled to rely on the intra-group exemption when it provides these services. That's an exemption that exists within the Payment Services Regulations 2017. If that argument was right, this business would be lawful. Unfortunately, if tested, the argument is likely to fail, and if the intra-group exemption can't be relied on, EDD is probably committing an offence every time it provides a payment service to these vets and their customers, which is obviously hundreds and thousands or perhaps more of occasions.
Is that the direct model?
I'm so sorry.
Is that the direct model he's talking
Yes, it
about?
is. Yes, that's the
I thought the direct model wasn't adopted until after the acquisition of the company.
correct, and that's precisely what Mr. Finney was talking about. This is October 22, so 2 years after acquisition.
Right.
And yes, until the acquisition, IVC vets were commercially completely separate, and obviously one's.
Just to make sure I've got this straight, Mr. Finney is saying, I think the indirect model is probably okay, but you haven't actually asked me to drill down into this. It's my working assumption it's okay for these reasons, and I can't see any reason why that should be wrong. But as far as the direct model is concerned, there's an argument that it's lawful, but I think it will fail, and therefore you're probably in breach.
Yes, and that was a state of, so the direct model, as we're calling it, was something which had been introduced from March 2021. So in other words, from a few months after completion, with the aim, obviously the understandable commercial aim, that when a much larger operator in the veterinary sphere buys a particular services business, it obviously wants to achieve the synergies, or whatever the jargon would be, and use that services business to service its existing large pool of customers.
So if that model turns out to be unlawful, it wouldn't be the foundation for a breach of warranty because it post-dates the acquisition, but it would nevertheless be a reason why a protected disclosure might be made. Is
Indeed.
that right?
Yeah. So the warranty claim can only relate to matters up to or at the date of completion.
Yes.
And after that, and obviously as soon as completion occurs, then the subject matter of the sale is no longer warranted.
But the change of position insofar as the underlying case is concerned, does that really only affect the indirect model, or does it affect both?
Well, it affects both, and indeed, as I'll show you in a moment, when we go back to the judgment which I've broken off from, one can see that Judge Bird specifically draws that together. So let me take you to that in a second. So I've shown you therefore the source of the paragraph 19. Paragraph 20 is the notice of warranty, so 2 years to the day after the sale, and in the usual way, there would be a limitation period, so to speak, or a maximum time period for giving notice of claims, and that is when it expired. And just for the court's note, but I don't propose to take you to it, that supplementary bundle, tab 11, page 59 is the breach of warranty notice. And then paragraph 21 is what in our skeleton is called the Finney email. So that refers to the situation immediately after Mr. Lay had been dismissed. And one can see what the judge sets out there. And on the 21st of June 2023, Fox Williams sent an email to Mr. McCarthy, who was the replacement CEO, and that summarised the advice that had been given since mid-October 2021. So it's a summary of previous advice.
But it's still advice to EDD.
Indeed, it's purely EDD, the passage cited by Judge Bird is to say that the direct debit and remittance parts of the EDD service, that is dealing with the indirect model. I should have read that out. Dealing with the indirect model, Fox Williams said that the direct debit and remittance parts of the EDD service are provided by, and then the third parties, under arrangements with those third parties. And he says those third parties are FCA authorised to provide regulated payment services, so the direct debit collection and remittance services are probably provided lawfully.
That's consistent entirely with what Mr. Finney said at an earlier stage.
Indeed, it perhaps slightly firms it up, but it's only consistent. And again, if we can just look at that document in the supplemental bundle, it's tab 15, page 113. Starting in the middle of the page, Mr. Finney writing to Mr. McCarthy, the new CEO. And he records that EDD has been an FW client since mid-October 2021, so this all post-dates completion. And he says that they've advised EDD on 3 matters, of which we're only concerned with little one: regulated payment services issues. And he introduces that at the bottom of the page, that when EDD first instructed us, it was to advise on these issues, and he refers to a colleague who was originally the lead advisor, and then he's been the lead advisor since then. And he says he hasn't done much recent work on the issues, and at the bottom of the page, the last sentence on that page, there's a summary of the issues below in case it's helpful. And turning over the page, after dealing with the trademark matters and the contract matters, he then has a subheading in italics, a summary of the regulated payment services issues stroke advice. And it is, as you probably already know, 1, EDD provides software, business development and other services to A, independent vets, and B, the vets in the IVC group. Little 2, the services provided to the independent vets include the collection of direct debits from the Pets Health Club members' bank accounts and the remittance of the funds to the vets' practices. The direct debit and remittance parts of the EDD service are provided by Bottomline and will go cardless under an arrangement between EDD and Bottomline on the one hand and EDD and go cardless on the other. Bottomline and go cardless are FCA authorised to provide regulated payment services, so the direct debit collection and remittance services are probably provided lawfully. So that's the situation, therefore, in relation to pre-completion. What's relevant, therefore, to this High Court claim concerning the SPA. Little 3, the services provided to the group vets, so that's subheading B in point 1 of this section of the email, the vets in the IVC group. The services provided to the group vets also include the collection of direct debits from the vets' Pets Health Club members' bank accounts and the remittance of the funds to IVC. However, EDD collects the direct debits and remits the funds itself. In other words, it doesn't use the third-party providers, Go Cardless or Bottomline. When EDD does these things, it probably provides regulated payment services, although A, it isn't FCA authorised, and B, until recently it wasn't in a position where it could properly rely on the exclusions or exemptions in the payment services regulations either. The result is that over a period of several years, every time EDD collected a direct debit from a group vet's customer and remitted the proceeds to IVC, it probably committed an offence. And then he goes on to describe the regulatory risks that result from that situation. Finally, at the top of 117, he confirms that in the future, FW will only accept instructions from you and it will only deliver its advice to you unless you ask it to do something else. So, in other words, Fox Williams were not Mr. Lay's client, even though he was the person responsible until his dismissal for seeking and obtaining that advice. The company EDD's advisor, and Fox Williams continued to owe duties only to EDD, which is of course controlled by IBL. Now, the judge, just going back to page 46 of the main bundle, the judge has another subheading, what Mr. Lay was told about the lawfulness of the EDD business. But just before we get there, one notes that up to this point, all that the judge has done, and that of course reflects the state of the evidence before him, is refer to advice that was given not to IVL, but advice given to EDD. But although that's what he's done, he hasn't noted or reflected on it. And then under the subheading, what Mr. Lay was told about the lawfulness of the EDD business, on the 16th of November, says the judge at para 22, EDD, then in the effective control of Mr. Lay, received advice from Fox Williams casting doubt on the legality of the indirect model. And that the judge then cites a sentence, I'm not confident, this is Fox Williams, I'm not confident that using GCL or BTL is sufficient to ensure that EDD is not performing regulated payment services. And over the page at paragraph 23, Mr. Lay's position is that the advice was based on a misapprehension of the central facts, and then there's a quotation from Mr. Lay's witness statement. Mr. Lay informed Fox Williams that this understanding was incorrect on the call that we arranged in the email chain. Fox Williams therefore provided updated advice later in November, which I then circulated widely. 24, there's no suggestion that the 16th November 21 advice was shown to IVL, and in any event, it was superseded by the summary provided to IVL on the 21st of June 2023. So, on the judge's own finding, legal doubts that were expressed or a lack of confidence on the 16th of November was advice that was superseded. The judge didn't cite any evidence, nor was there any, to undermine or present a different picture to the explanation from Mr. Lay, which I'll take you to in a moment, nor was there any. If we could keep open that part of the judgment and go first of all to Mr. Murdoch, the DLA solicitor's witness statement, at tab 27 of the supplemental bundle. You'll find this 16th of November 2021 advice from Fox Williams, or communication from Fox Williams, towards the bottom of page 260. It's the penultimate entry on the page. Fox Williams, and this is Mr. Murdoch's summary, Fox Williams A expands on concerns about illegality of processing payments for non-IVC practices, the indirect model, in addition to the illegality of the direct model. Advises Mr. Lay not to migrate any more IVC clients away from GCL or BTL, in other words, don't put any more people on the direct model. And C, flag to Mr. Lay that they have initial concerns about illegality in relation to non-IVC practices, but more information is required for a final view. So that's the defendant's own summary of the state of doubt at that point. And if one then goes forward to see what Mr. Lay said about that in his witness statement, which is what the judge refers to in the next paragraph. It's page 308 in tab 30. And the judge cites the latter half of this paragraph. I'll pick it up a little earlier. 41.3. At his paragraph 24.1, Mr. Phillips, who was another executive from IVC, suggests that I withheld Fox Williams' email advice of the 16th of November 2021. This point is also included in Mr. Murdoch's chronology. In fact, as above, Fox Williams' conclusion that using GCL and BTL was insufficient to secure regulatory compliance under the indirect model arose from a mistaken assumption as to the factual premise on which EDD was trading in relation to the flow of funds, which was materially incorrect. I informed Fox Williams and Ms. Mardy McGregor that this understanding was incorrect, and then this is what the judge cited, just this sentence, that this understanding was incorrect on the call that we arranged in the email chain. Fox Williams therefore provided updated advice later in November, which I then circulated widely, as I've already explained above. So the position on the defendant's own evidence was that there was an email on the 16th of November from Fox Williams, which Mr. Murdoch summarises as saying Fox Williams have initial concerns about illegality but require more information. Mr. Lay then gives evidence that he flagged up Fox Williams' mistaken assumption and that updated advice was then provided later in that month and that he circulated it. So that's the already nothing to displace the conclusion that the advice, which in any event was given to ECD, not IVL, the initial concerns were allayed. But of course, one also has Fox Williams's later emails. I've shown you the email of the 7th of October 2022, and I've shown you the email of the 21st of June 2023. and in both of those, Mr. Finian Fox Williams says, well, it's probably lawful, and he hasn't seen anything to suggest otherwise, etc. Now,
Well, now he's got the correct explanation of how the model works.
I'm so sorry, Elaine.
Now he's got the correct explanation as to how the
Yes.
model works. So
Well, exactly.
you start with Fox Williams expressing concerns about both models, indirect and direct, but say they might need some more information about direct model. There's then a conversation between Miss McGregor and Mr. Lay, in which a misapprehension is corrected in relation to the indirect model, and that subsequently then comes out in the wash with revised advice, which is passed on from EDD to IVC. And as far as the direct model is concerned, Fox Williams then comes to the conclusion that that's not legitimate. So they've actually changed their minds about the indirect model on the basis of what they were told by Mr. Lay.
Yes, that's absolutely right. If I was being pedantic, I would say changing mind in a sense overstates the strength of their
Sure.
position first, but they've come to a conclusion which allays their initial doubts. And,
Yes.
and of course, if it were otherwise, if they hadn't allayed those doubts, then what Mr. Williams is saying in his email of the 7th of October 22, and what he says even more firmly in his overview on the 21st of June 2023, provided after dismissal, would be completely wrong and misleading. And it would be an extraordinary thing for a solicitor to do that. And any suggestion that there was some sort of secret channel of advice would involve saying, in effect, that Fox Williams have subsequently provided a thoroughly misleading account of what their actual advice was. And there's not a shred of evidence to make such an allegation. To be fair, I don't think Mr. Dotsey himself has ever made it. That we say is the situation. Now, the judge didn't refer at all to advice given to IVL itself, even though two firms were involved, as I've said. DLA Piper, who is still on the record and whose regulatory partner has actually given the main witness statement, secondly, Pinsons, i.e. Pinsent Masons, and one can see that, and there's a further wrinkle to the story which I need to tell you about as quickly as I can, which comes up in 2022. If we could go first of all to the supplementary bundle tab 3.
Mr. Bayar, how are we doing on time?
We're doing fine, my lord. I'm going to. I'm very conscious of the clock.
Right.
I hope to avoid even the mildest form of guillotine.
Where did you ask us to go next?
Tab 3 of the supplemental bundle, page 17, my lord. So this is an email on the 16th of March 2022 from somebody whose name we haven't mentioned so far, Keith Chandler, who was then the M&A director for IVC. And he writes to Mr. Lang and he says, can you respond in layman's language? And he attaches a PowerPoint slide deck prepared with guidance by our solicitors, and you can see in the second main bullet point, the solid bullet point about to which is Derek. He says EDC using an IV Sun and then the name Pinsons, which is why we can see that Pinsons were involved. And I'll just go back up so his first question is it possible to revert to using a PSP, a payment services provider, so Go Cardless, for example, for IVC transactions? This is effectively the same as EDD's current model for non-IVC transactions. In other words, the indirect model, which was the only model that had been in place up to completion. Exactly what payment service is EDP performing in that model that requires FCA authorization? I know you emailed to us earlier, but we don't understand that a PSP cannot sublet their FCA authorization. What does that mean, and exactly why is the PSP not allowed to continue processing transactions for EDD? And what we'll see is that at this stage there seem to be further wobbles, if I can put it like that, but which again were eventually overcome. So if we look at the slides, you may have to turn the bundle round, sorry about that. So page 19, with the colouring on it, IVC background, and you can see the penultimate bullet point for IVC transactions. EDD is likely to be performing payment services for which it must be authorised by the FCA, they assume that they will be covered by an intra-group exemption. We have confirmed that the exemption does not apply to the current business model. Therefore, EDD must either change the business model or obtain FCA authorisation. So that's the direct model.
Who's the we here?
Well, one assumes it's Pinson's, because Mr.
Right.
Chandler said it's been prepared with guidance, but it's although it's an IVC slide pack, the language suggests that it's legal advice. And one sees that at the bottom that there's the heading legally privileged and confidential. So this is therefore one piece of advice, or part of some advice that was shared with Mr. Lay, that was given to the company, or the output of some advice. And then the final bullet point, for non-IVC transactions, EDD believed that PSP was performing payment services for which was authorised by the FCA, and EDD was only performing ancillary support services and therefore didn't need to be authorised by the FCA. EDD now believes that it is in fact performing payment services for which it must be authorised by the FCA, that it's been relying on PSP subletting their FCA authorisation to EDD. But PSP is not permitted to do so, and therefore EDD must be authorised by the FCA. All that's not very good, but then one sees EDD has not adequately explained what payment services it believes it is performing in this business model, and therefore why this business model cannot continue, which was a business model concerning two of the largest payment service providers in the UK, who on this account would therefore also be implicated in some sort of breach of the regulations. But IVC and their solicitors are therefore clearly saying, well, we need to have an explanation of what the problem is, and the same request for an explanation is given at the bottom right hand corner of page 20 and in the right hand column on page 21. So I'll just refer you to that. So that's a further wrinkle, so to speak, which the Judge Bird, doesn't mention at all in his judgment, but it comes up came up in the evidence before him. So what then happened was that Mr. Murdoch, in his table at page at tab 27, page 262, deals with, for the entries for 27 and 29 September, cites some other advice from Mr. Fox Williams. So on the 27th of September, Mr. Finney is recorded as saying, in the period before EDD joined the IVC group, the whole of EDD's payments business was probably unlawful. So at that point, Mr. Finney...
Sorry, Mr. Bale, where are we looking?
This is Mr. Murdoch's witness statement.
Yes, in the table, but whereabouts?
Halfway down page 262, entry for 27 September 2022. So Mr. Finney then provides advice to EDD that, quote, in the period before EDD joined the IVC group, indirect model, the whole of EDD's payments business was probably unlawful. So that's obviously different from what he had said in his, or what he later says. It appears that Mr. Lay did not share this with IVL at the time or subsequently. That's what Mr. Murdoch says, as we'll see. That's completely wrong. 29th of September, same sort of point. In an email chain between Fox Williams and EDD, Mr. Finney of Fox Williams advises EDD seems to be unlawfully providing regulated payment services to its non-IVC group customers. And then at the bottom, it appears that Mr. Lay didn't share that advice at the time or subsequently. Now, I want to show you, first of all, a conversation which took place on the 30th of September 2022. So just immediately after this advice. And that conversation was in a Teams meeting, and the Teams meeting was recorded, and we have a transcript. So we have the ipsissima verba of all concerned, and it's at tab 5 of the supplemental bundle, page 25. For the court's note, the persons on the call are introduced in a call, another transcribed Teams call the preceding day. That's tab 4, page 22. So I'll just tell you, so Nishi Taylor is an in-house lawyer for IVC. Mr. Murdoch is the DLA partner. Chris Finney, who's given the initial CH, is the Fox Williams partner, as you know. Mithun Patel is the then head of M&A, I think, or compliance perhaps, head of compliance, sorry. No, he was group of M&A director, forgive me. He was an IVC executive. And then Mr. Ray. So this call does two things. The first is it discusses a proposal from Mr. Murdoch of DLA as to how an application would be made to the FCA to regularise the position for the direct model. And what Mr. Murdoch proposes, you can see in page 28 of the bundle. Starting at line 409, so S is S for Stewart Murdoch. He talks about the real crux of his concern. He says he understands the debates that Mr. Finney's illustrated between stating a defensible position, which is likely to lose, versus full transparency. We absolutely have to have that debate on vis-a-vis the applicant, that's the applicant to the FCA for authorisation, the EDD. If the applicant is a newco, we don't get into that debate in the application. It doesn't come up. You might have to refer to EDD, well, you might have to refer to IVC, you might have to refer to EDD's business. You don't even have to refer to EDD. You just have to say you're going to provide the same services, and then at line 420. But the point is, any reference to EDD in a newco application is going to be as a third party, not somebody who the FCA is inherently scrutinising. The FCA is inherently scrutinising newco. But in an EDD application, the FCA is inherently scrutinising EDD. And so you're at least one step removed, which A, takes you out of the regulator under a PRIN, that's the principles in the FCA guidebook, to actually, and I'll just finish this point, Cliff, and come to you, to disclose that. B, it's not the actual subject of scrutiny. D, C, it doesn't automatically trigger an enhanced plus category in the FCA. And D, it might never actually get a question, because you know from an FCA perspective, the business case, we don't expect it to go outside the four walls. The business case is the instructions of the case officer. You have to make sure the four walls of the business case are internally consistent. There's nothing which, to you, leaving to the discretion of a relatively lowly qualified person, not to be pejorative either, doesn't make complete sense. So what he's saying is, let's ignore the fact that we appear to have been in breach on hundreds of thousands of occasions for the last year and a half. We'll put in an application, blithely put in an application for newco and hope that it flies under the radar screen. And that wasn't a proposal which appealed to Mr. Lay or Mr. Finney, and perhaps fortunately for all concerned, it didn't go ahead. That was the first bright idea. The second aspect of this conversation was a different one, which we can see starting at page 31, after there'd been some pushback against Mr. Murdoch's suggestion. And 9677M, which is Mr. Mithun Patel, the Group M&A Director for IVC. Understand, Cliff, I'm not asking you to time any of this just yet, I just want you to understand. At one point again, sorry, stupid question, steep learning curve. The reason for the non-compliance is potentially the stuff that we do for the group. The stuff outside of the groups, outside of IVC, is go cardless. And then he then has that explained by the in-house lawyer, Nishi, it's 682. The transactions that aren't for IVC, independent practice and so on, are currently the direct debit collection piece is done by go cardless. So we, EDD, then provide wraparound services, but not the actual regulated payment services. And then Mr. Taylor says the problem is that Cliff is saying that go cardless want to walk, and then Mr. Lay says, well, there are two issues. The first issue is that they want to walk, they want to double their price, and he doesn't want to pay it. And then he says, 694, there is also from a legal perspective, the possibility at the bottom of the page that easy direct debits is deemed to be instigating those payments. Is that the right language, Chris? And then Mr. Finney says, yes, initiating payments that are processed then by go cardless and bottom line, and initiating payments is a regulated activity. Now, that's not a position, I must say, that go cardless or bottom line have ever flagged as being an issue, but it is a possibility. And we've had advice that there is every chance the regulator would look at that and say, you're initiating payments, what the hell are you doing? That's a regulated activity. Totally different to reliance on the intra-group exemption, where we think we've made a case, but we also think there's a good chance the regulator will reject that argument, and then Mr. Patel says, if it rejects that argument, Cliff, that's a non-compliant bit, yes. So at this point, there's been another doubt raised by Fox Williams, it would seem, as to whether, even on the indirect model, EDD is a payment initiator. So that's on the 3rd of September, and contrary to what Mr. Murdoch had suggested, without it appears having had sight of this transcript of the team's reporting, so far from being concealed, this was actually volunteered and transparently put forward. But it is also dealt with in Mr. Lay's evidence to Judge Bird, which, like this whole episode, is not referred to anywhere in the judgment. And one sees that at the end of the witness statement. It's tab 30, paragraph 53, page 316. Following receipt of the above emails, on 30th September 2022, I met with, and then he refers to this meeting, an electronic meeting, a remote meeting. In paragraph 54, he then summarises the transcript which I've taken. So, as Mr. Lay says in the fourth line from the end of paragraph 54, it follows from this that the defendant was fully aware of the substantive point behind Mr. Finney's 27 and 29 September 2022 emails prior to the ET hearing. Going back to my point about election, if there was a doubt connected with this issue about whether EDD, despite the fact that it had been trading with the two largest payment service providers in the UK, was somehow breaching the payment service regulations by deemed to be an initiator of the payments, if there was such a doubt, it was completely on the radar screen. And then Mr. Lay explains that, in fact, this is paragraph 55, as per the Claimants Board case, it's not thought this was a correct concern. EDD has never initiated payments under the indirect model pre or post completion without waiting privileging advice which the claimants have received. The claimants' previous case reflects the reality. The direct debits which EDD had were not push payments and were not therefore initiated by it, which is not very surprising because otherwise those two very large payment service providers would have a rather defective business model. So, and that is why a week after this call of the 30th September 22, we see Mr. Finney's email of the 7th of October, which I took you earlier, which says, well, our working assumption is that this is lawful, the indirect model. I've seen nothing to contradict it. His fears have therefore been allayed. And why on the 21st of June 2023, he says it is lawful. That was a potential issue. It was properly flagged up with IBL. They were aware of it. In Mr. Lay's view, it wasn't a true issue, but it was there to be considered. So we say, well, there's simply no basis for the judge to have found that there was a change of legal advice. Let me draw the threads together in the last 4 or 5 minutes before I give my promise to sit down. How did the judge, in principle or otherwise, take wrong factors into account the outcome? Number one, he considered legal advice as the justification for what would otherwise be, as he recognised in paragraph 67, a abuse of process by changing position, or at any rate, if he was not wrong in principle to consider it, he was wrong to consider it in the absence of exceptional circumstances. Number two, in any event, he relied on what he considered to be changed legal advice without having had full or really any disclosure of the relevant legal advice. And as a result, he was unable to identify any of the following five matters. Number one, actual advice given to IVL. Number two, the belief of IVL.
Don't go so far.
I'm so sorry.
Number one, actual advice given to us.
Number two, belief of IVL at the time it caused its position to be taken in the ET. As we all know, there's a distinction between the advice you're given as a client and the state of mind you then have following that advice. Number three, the judge was unable to identify the change in the advice given to IVL, if there was a change, and when it changed. Number four, the belief of IVL. At the time it advanced its inconsistent plea in the High Court, defence and counterclaim. Or number five, it's different, the belief of IVL now, at the time it's continuing to put forward a position. The third error that Judge Bird made was to rely on advice given to EDD, not IVL. Distinction seems to have overlooked. Fourth error was that he failed to assess the significance in the context of his finding that a change in position was justified by a change in advice of any of the following three matters, each of which he should have assessed. Number one, IVL's allegation of breach of warranty in October 2022.
Sorry, whispering.
We can't hear you.
Sorry, my throat is getting a little hoarse. Number one, IVL's allegation of breach of warranty in its notice of October 22. Apologies, my lord.
Yes.
Number two, the disclosure by the claimant to IVL at times along the way that the indirect model might be unlawful. There were arguments against it. Number three, the acknowledgement by IVL in Mr. Chandler's slide deck, the putatively Pinsent slide deck that we looked at in March 2022, that Mr. Lay had raised potential issues which they didn't understand about the indirect model. And the fifth failure, even if all of the above are not valid criticisms, Judge Bird failed to consider whether the change in position arose out of matters which IVL knew about or could reasonably have ascertained at the time of the ET proceedings, ET hearing. And I finally want to show you, and it will take only 2 minutes, an interesting paragraph in a different judgment, which isn't mentioned in the skeleton argument, of Lord Justice Sales, as he was, in a judicial review case called Gerber or Gerber. It's tab 18 of the authorities bundle. And the passage is at page 356 of the bundle. This was a case where this court overturned the High Court judge who had granted a significant extension of time for applying for judicial review to quash planning permission. There were two periods of delay, and the second period of delay was one in which the applicant had gone to original solicitors called Merritt and Co, who said you're too late. And then a few months later, he'd gone to some well-known solicitors in that field, Richard Buxton, who had taken a more bullish view. And so 4 or 5 months later, under the wise guidance of Mr. Buxton, a claim was brought, and that claim was upheld, was permitted by Mr. Justice Dallas. And paragraph 52, Lord Justice Sales says, I consider that Mr. Gerber had no reasonable explanation for the further period of delay after 19th March 2014 when he learned about the grant of planning permission. Says, I think the judge accorded inappropriate weight as a matter of principle to the fact that Mr. Gerber was acting on the basis of legal advice he received. And 53, he says this, the fact that a person acts or omits to act on the basis of legal advice does not make him less responsible in law for his actions or omissions to act.
It's all right, don't read it out. It's a long paragraph. It's not unfamiliar.
I'm so sorry, my lord.
I said, don't read it out. It's a long paragraph.
I'll just let your lordship. Thank you very much. I'm grateful. It speaks for itself.
Yes.
And I just wanted to say, in my final seconds, that although Lord Justice Sales there refers to 3 considerations in the planning context, they will actually apply here. First of all, his little 1, just above letter E, that there'll seldom be sufficient evidence about the precise context to allow a court to assess it. Well, that applies also here. His little 2 is that this would undermine the protection, that's at letter F, for such other parties, which is supposed to be provided by, in this case, the abuse of process doctrine, if the recipient was entitled to refer to private exchanges, which the others know nothing. As Lord Justice Sales says, there's also a risk of shopping around. The reality is you can often find new advice if you want it. And thirdly, the interest of the person receiving advice are protected in another way, because of course you've got your negligence claim if there is one against the advisor. So all of those factors apply here. There's obviously a respondent's notice. I'll have to respond to that afterwards. I'd simply note that there is, with great respect to Mr. Totsi, little if any attempt to say how his criticisms of the judgment were on points which he lost on, which they test for the intervention of this court. Thank you very much.
Right. Thank you, Mr. Bayar. Mr. Strelitz, will you do your best to answer my point about the jurisdiction to make the order, either now or at 2 o'clock, whichever you prefer.
Yes.
If it assists, I've managed to locate the documents on the CE file. And I can show those to you over lunchtime.
All right.
It appears that the parties had as an agreed position that there was a jurisdiction to do this under Tribunal EAT Rules 65. or under CPR 3 point something. It's in the letter of the 12th of December 2025 from DLA, and then replicated in your scholarship argument, Mr. Strauss.
That is far better recollection than me at this point, my lady. Thank you. If I may opt for the 2 o'clock option.
Yes,
Yeah,
very
thank
good.
you.
Well, it looks as though your highly qualified research assistant has maybe found the answer already.
Well, it occurred to me Mr. Strelitz might have difficulty locating the documents over the shorter journal.
Right, Mr. Totty.
Yes. Grateful. Lord and ladies, can I start with the legal authorities? They were addressed by the judge in paragraphs 43 to 54 of his judgment. That's in the core bundle, tab 5, pages 49 to 51. And we do not take issue with his summary of the law. And although my learned friend took you through a number of those authorities, it didn't seem to us, and it doesn't seem to us, that he is taking any issue with the law as it was set out by the judge. Nevertheless, I do accept it's perhaps helpful to look at some of the cases which the judge identified and which my learned friend took you to. And I'd like to start, please, with the decision in LA Microgroup. That's in your bundle of authorities at tab 7. And can I go straight to page 105? And as the court will be aware, this was an appeal from a judgment of Judge Jarman. It followed a trial. This is a theme that I'm going to come back to because the fact that there had been a trial and a proper investigation of the facts from which the court was then able to draw conclusions is something that we haven't had here, and which ultimately my submission is what should happen. We should allow these matters to go to trial. The outcome of the application before Judge Bird was correct. He dismissed it. I do not say that any of those matters have been finally determined by Judge Bird. On the contrary, they are all matters that are open to be explored at the trial when we can have a full and proper investigation of the facts rather than selective cherry picking, which is, with the greatest respect to my learned friend, what you've been subjected to this morning. So it was an appeal to Judge Jarman, and the judgment of the Court of Appeal was given by Sir Christopher Floyd. You've been taken to the relevant passages, but I'd like particularly, please, to focus on what Sir Christopher had to say at paragraph 26, which is page 114 of the judgment. Picking it up at the bottom there, he says, it's clear that this form of estoppel by conduct is one which is approached by means of a broad, merits-based assessment and is not constrained by strict rules as, for example, issue estoppel. Now, pausing there, a broad, merits-based assessment in our submission calls for a proper investigation of the facts. It's the point I've just made. And it's, unless you have the clearest possible case to deal with this on a summary interlocutory application, is, we would submit, asking for trouble. In this case, a number of facts are in dispute. In particular, they concern the exact nature and extent of the alleged protective disclosures made by Mr. Lay, an analysis of the response to his application in the Employment Tribunal, and importantly for the purposes of the appeal, what the respondents to that application knew or understood to be the position as at the 30th of June 2023. Now, this was not limited to legal advice, as the judge recognised, Judge Bird recognised in paragraph 67 of his judgment, where he says that is a change of the facts as understood and a change in the legal advice given. Now, I know that my Lady Justice Andrews picked up on that and said, well, what are these facts? He doesn't summarise them in his judgment.
And I accept that as a criticism of the judgment, but I don't accept it as a criticism of my case, because there was evidence before the judge. It's perhaps unfortunate that a lot of it is not before you now, because this was an appeal based on the grounds of appeal that was focused solely on the question of legal advice, not whether there had been a change in the understanding of the facts. And you will have seen, for example, that the witness statements of Mr. Phillips, which I don't think you've been taken to, and Mr. Murdoch are extracts, not full versions. I will come back to this probably this afternoon, if I may, when I deal with the chronological account of facts in Mr. Murdoch's statement, the table that you were taken to bits of, because there are some important statements of fact made by the witnesses about what they did, and more importantly, what they did not know was going on after completion, when Mr. Lay remained in control of EDD, and when it was our evidence, it is our evidence, and will be our evidence at the trial, effectively did not share any information regarding what he was doing, or indeed how EDD ran its business.
Are any of these facts anything to do with the models and how they operated?
They're critical to it, because, and actually, in a sense, the passages my learned friend took your ladyship to earlier today demonstrated this. You'll recall that he relies on the fact that Mr. Finney originally expresses some doubt as to the lawfulness of the indirect model, and he is then told certain facts by Mr. Lay. Exactly what they are, we don't know, because that's not explained. As a result of which he concludes, oh, well, that's all right then. So, yes, the precise detail of what EDD was doing and how it was doing it clearly is and was very relevant to whatever conclusions one then could draw about whether the business was being conducted lawfully or not. I do submit that that first part of what Sir Christopher had to say is important. If we then go on, please, to go back, sorry, to Sir Christopher Floyd's judgment, and picking it up on page 115 at the top, he says, the matters to consider include, but are not limited to, those enumerated by Justice Ginsburg in the New Hampshire case. It is material to ask the question whether it is apparent that the earlier decision was obtained on the footing of or because of the stance taken by the party in the earlier proceedings, and so on. Now, you were taken, I think, to the factors that were enumerated by Justice Ginsburg in the New Hampshire case, and you'll note, if you wanted to see them again, they're in tab 6, pages 98 to 99. Can I just take you there?
Yes.
Because I will highlight something if I may. Oh. Give me, I managed to. So at 99, the judge, having set out the three considerations which have been read to you, says this: in enumerating these factors, we do not establish inflexible prerequisites or an exclusive formula for determining the applicability of judicial estoppel. Additional considerations may inform the doctrine's application in specific factual contexts. So the whole point of the doctrine is it's a flexible one, and of course it's very fact sensitive, which means that a court needs to have a good and full understanding of the facts in our submission before deciding whether the estoppel arises or not. And my learned friend took you to the observations of Justice Ginsburg at 101. If you just go down to that. So the first indent in where he referred to the passage that says New Hampshire also contends that the 1977 consent decree was entered without a searching historical inquiry into what that language meant, and so on. And the judge records that they are unpersuaded that its position in 1977 fairly may regard it as a product of inadvertence or mistake, and so on. We say in this case that it is necessary for a court at trial to have a proper and full investigation to see whether there is a legitimate justification for what was found to be the contradictory stance taken by IVL in relation to the indirect model. And in my submission, there is enough material before this court, and there was certainly enough before Judge Bird, for him to conclude that there needed to be a full trial of the facts. Indeed, I think, as he said in paragraph 67 of his judgment, it's page 52, about 5 lines down, paragraph 67, he says, in my judgment, the administration of justice is best served by determining that issue, that's the lawfulness of EDD's pre-completion model, in the light of the facts as found by the trial judge and by applying the law as it is found to be. And so it feeds into the point that the proposition I've already made. And incidentally, notwithstanding the way in which the judge dealt with matters, if there's any doubt about this, we submitted to the judge below that the appellants can still advance their case on estoppel before the trial judge. And there's a reference to that in the questions that the judge put to a man from Mr. Hockhauser, who was then representing the appellants. If you want the reference, it's in the transcript of the hearing below, or the extract of the transcript of the hearing below, in the supplementary bundle, tab 33, page 350, at the page within it, like page 141, lines 5 to 7. I don't intend to take you to that unless you wish me to. But can I go back to Sir Christopher Floyd at paragraph 26 and his third proposition, which is, it is material to ask the question whether it's apparent that the earliest decision was obtained on the footing of or because of the stance taken. That, and so on, that indicates the importance of the causative role of the contradictory stance. It emphasises that the contradictory argument must have been material to the earlier decision. And as you'll see at paragraph 26, Sir Christopher Floyd emphasised that absent that factor, i.e. that the earlier decision was obtained on that footing and so on, the doctrine did not apply. And that is relevant here to our respondents' notice, if we need to rely on that, because it is clear when we look at the decisions of Judge Cadney that Mr. Lay's application was dismissed regardless of what is now said to be the contradictory stance of IVL.
You're not saying there's a strict causation test?
No, not a sort of but-for way, no.
Got
But
to be a factor. It
yes,
was obviously a factor. Whether it was the only factor doesn't matter. But
Well-
you'll obviously try to seek to persuade us otherwise.
I will, indeed. And indeed, when one looks at the judgment, I do submit it cries out that if nothing had been said about the lawfulness of the indirect model, it wouldn't have made a blind bit of difference.
Right. Well, that's a suitable note on which to break off. Resume at 2 o'clock.
Court rises, able.